Welcome back after the lunch break, which put me in a very difficult position because everyone is full of food and really sleepy. So hopefully this would be a thought-provoking presentation, and I will measure time as well to try to constrain myself within 30 minutes. So my topic, as you can see in the brochure, is the statement that actually all wars start with a human decision, which is to attack another country. And what is not printed in the brochure is the subtitle. It says, "The legal struggles to hold responsible the Russian state officials for aggression and the impact of the success or failure of such attempt on the development of international law." So shortly, this presentation will assess how to prosecute the crime of aggression against Ukraine and why is it an attempt we should follow for a more secure world. I will touch upon basic questions. First of all, why is it necessary to hold the Russian leaders responsible for the crime of aggression? Who are the persons who should be held responsible? This will be really brief. And then the majority of time will be allocated on the possible solutions. In the first part, I will present solutions which I think rather pose problems to the current case and for the future of international criminal law. And in the end, I will present two proposals which I believe would not only make justice for this specific case, but which would also lead to development of international criminal law and general international law as well. And you can see those possibilities in general, which I will discuss later. So first of all, there might be a question on whether it is actually necessary to address the issue of the crime of aggression against Ukraine. Some may argue that there is already an investigation before the International Criminal Court concerning the situation in Ukraine. So why duplicate this effort? One might argue that there's already an aggression case before the International Criminal Court between Ukraine and Russia, although it's seemingly about genocide and the application of the Genocide Convention. It is actually about the aggression against Ukraine, but that's a different topic. And again, some might say that there are already sanctions against both Russia as a state and Russian individuals. But first of all, concerning the ICC, the investigation only covers war crimes, crimes against humanity, possibly genocide. Aggression is not amongst the crimes, and there's a good reason for that. We will cover this later. Before the ICJ, of course, the case concerns state responsibility, which is obviously very important for the international rule of law, but on itself, it cannot really contribute to prevention. Because for that, another pillar of international law should be addressed as well, which is international criminal law. The reason behind this, and why I state that, is if we only cover state responsibility, there is a very high chance that perpetrators of the crime of aggression would regard to the state as a scapegoat, meaning that if the state will be liable and responsible for the act of aggression, but the individuals who made the decision to wage war will not, then it's a clear message for impunity. So, and another clarification, I'm not arguing that international criminal law is the solution. I argue that international criminal law and all the other efforts together would create a better and stronger international legal system with better preventive measures. And finally, concerning sanctions, I think strong arguments can be made that these are rather political measures, although they are enforced by legal means, but they do not address responsibility, legal responsibility. This is why I say they are rather political measures and not legal law enforcement measures. And obviously, this is a good opportunity to actually tackle all those challenges which are entailed in a crime of aggression case, because obviously this is a very strange novelty in contemporary international relations, the war against Ukraine, in a sense that it is surprisingly old-fashioned. This is a very classic war for domination and not only occupation but annexation of territory. This is why if we do not prosecute the crime of aggression in this very blatant violation, then there's a chance that in the future we will not be able to prosecute any other crimes, simply because saying that if such a blatant violation remains unanswered, then selective justice arguments would be really strong afterwards. And I do not want to argue a lot about the persons who should be targeted with a case of aggression. It's obviously President Putin, Foreign Minister Lavrov, or Defense Minister Shoigu. One note here is that the crime of aggression is obviously a leadership crime, which means that only those people can be prosecuted who have a control over the state when it comes to decision making regarding war. So, although I'm open to questions in the discussion part, whether it is really necessary to address the crime of aggression in a ICL manner, now my presumption is that it is necessary and we should actually carry out justice based on an international response in ILC. And now let's see what are the possibilities. And the first possibility is obviously the International Criminal Court, although I forgot to follow up with my slide. So ICC. Ukraine is not a state party to the ICC. Russia is not a state party to the ICC. However, Ukraine accepted the jurisdiction of the court, and also 40 state parties referred the Ukrainian situation to the attention of the prosecutor. The problem is that first, Ukraine accepted the jurisdiction of the court for crimes against humanity, war crimes, and genocide, which means that aggression is not in the acceptance of jurisdiction. And there is a good reason for that. All crimes within the Rome Statute, which are war crimes, crimes against humanity, and genocide, with the exception of aggression, have a common jurisdictional regime, which means that the court, the ICC, can proceed if it has either territorial or personal jurisdiction, meaning that if the crime was committed on a territory of a state who is either party to the Rome Statute or accepted Rome Statute, then the court can proceed. Or alternatively, if the crime was committed by a person who is a national of a state party or a state who accepted the jurisdiction of the court. Problem is that the crime of aggression was put into the Rome Statute and the Rome Statute regime in 2010 after the Kampala amendments. And it was watered down significantly, and aggression is a crime which has a different jurisdiction regime. And it means that for the crime of aggression, the court has to have both territorial and personal jurisdiction, which means that for the court to be able to proceed, you have to have the consent of both the victim state, Ukraine, and the state, the national of which committed the crime allegedly, which is Russia. Obviously, this is not realistic. There is one possibility under the Rome Statute, which is a Security Council referral under Chapter 7 of the United Nations Charter, which concerns international peace and security. Again, this is highly unlikely because Russia is a permanent member of the Security Council with a veto power, so obviously it will not happen. There are some scholars who suggest that even if the Security Council in itself cannot refer the case to the ICC, the General Assembly can. Their argument is based on the Uniting for Peace resolution. I think most of you know this resolution, how it was used historically. It was also used in the Ukrainian conflict because the Security Council could not condemn the act of aggression, but the Security Council referred the case to the General Assembly by the Uniting for Peace resolution, which allowed the General Assembly to condemn Russia for the act of aggression. The idea is that based on this resolution, which, just to recap, means that if the Security Council is paralyzed because of a permanent member who is not taking part of the decision or uses its veto power, then the General Assembly can proceed in that given case. So this is why many believe that an aggression case could be referred by the General Assembly to the ICC. The problem with this solution is, first of all, it's highly unlikely that the General Assembly would actually do that. And even if it decides to do so, it would be against the UN Charter, even under the interpretation of the Uniting for Peace resolution. The Uniting for Peace resolution does allow the General Assembly to address the issue which was blocked in the Security Council, but it does not authorize the General Assembly to adopt binding resolutions. And even if the General Assembly for some reason decides to go to this direction, I think it would be highly unlikely that the ICC or ICC judges would accept such a referral, because it would not only be contrary to the UN Charter, but it would be contrary to the Rome Statute as well, which only allows the Security Council referral. If you missed this part, the Security Council referral means that there's no need for neither territorial nor personal jurisdiction. So this is why this solution was propagated by some scholars. The other possibility, as was proposed by the first prosecutor of the ICC as well, Mr. Ocampo, was to amend the Rome Statute so that to practically make it an ordinary crime, in the sense that either territorial or personal jurisdiction would suffice. This is a possibility I will discuss later as one of the proposed solutions. The other possibility is to just look back to the history of international criminal law and create another ad hoc tribunal. This can be an international ad hoc tribunal or a hybrid tribunal. Hybrid tribunal simply means that it is partially national, partially international. It can apply national laws and international laws, and it is usually integrated to the national judiciary system of the state. For the purely international ad hoc courts, the examples include the Nuremberg and the Tokyo trials, but it's not really a solution fit to today's context. And the ICTI, ICTR. Those two tribunals were erga omnes in a sense that practically every UN member state was obligated to cooperate with the court theoretically, because these courts were established by the Security Council under Chapter 7 of the UN Charter, which made the decision binding. So this would be the solution, to create international courts having jurisdiction over the crime of aggression without the consent of Russia. Again, this is highly unlikely, because for that you need the Security Council decision with the agreeing positive vote from the permanent members. Again, Russia has a veto, so it is not realistic to accept. There are talks about a hybrid tribunal, which would be erected by Ukraine and possibly the General Assembly or the EU or the Council of Europe, integrated to the Ukrainian judicial system, and the details can be nuanced depending on negotiations. This is a possible solution law-wise, because with an international agreement that is possible, but I don't think it, again, I don't think it would be a good solution. First of all, I think that for the legitimacy of the court, at least we can say that it would be contestable, because if the victim state is the one who is actually participating in the decision-making, there is a high risk that many actors of international law would not consider it as a fair trial. A hybrid tribunal is just as national as international, so it is contestable that immunity of head of states would not apply before such a court. And I don't even think that it is really realistic to hope that such a court would be established with a support which is convincing enough to be a realistic possibility. Lastly, there is, of course, the potential of a domestic procedure. It means that the crime of aggression would be prosecuted within national courts based on national laws, based on national procedural laws. It can be done theoretically through universal jurisdiction or territorial jurisdiction. The biggest concern regarding universal jurisdiction is that it is not entirely established that the crime of aggression is a crime with universal jurisdiction. At least I could not find any legal source for that. It is also problematic that since it's a national court, the immunity of head of states would apply before it, meaning that a state, according to conservative interpretation of international law, cannot prosecute the head of state of another state or other high state officials. And when I say no temporal limit, I mean that if I understood properly, conservative interpretation means that even if the person who was a head of state or a prime minister leaves office, functional immunity would still protect him, because the crime of aggression is always committed in the function of the official, so not in a personal capacity. So I don't think that universal jurisdiction and national proceedings would be a good answer. The other possibility is territorial jurisdiction, which practically means Ukraine, as the state on the territory of which the crime was committed, could prosecute the crime of aggression. Again, the biggest problem is that according to conservative interpretation of international law, immunity of head of states would apply, hence Ukraine would breach international law if decide to prosecute and can prosecute the Russian foreign minister or the Russian president. And it is highly unlikely that indictments or warrants would be respected, because it could not have an international character. And for the future of international law and international peace and security, impartial justice as a counter-argument would be highly likely to be raised against such a solution. It would not necessarily lead to a better preventive system, simply because this solution actually would mean a step back from the international legal order, and it would be a high proof or evidence that public international law simply does not work, because we are going back to national jurisdiction, national proceedings in breach of international law, because these proceedings could only be done in violation of the principle of immunity. And obviously, since it would entail national laws, it would not lead to the development and crystallization of international criminal law and the law regarding the use of force. And this is just a side note. I'm not sure whether you've heard about this. There is a thing called the Course of the Citizens of the World. This is a very interesting attempt to fill the gaps. It was actually created and promoted by some very well-known and respected figures, including Benjamin Ferenc. But actually, although I do respect the attempt, it poses more problems than solutions. First of all, to put you in context, this is rather an academic attempt in disguise of being a court. So some scholars practically established a theater in which they pretend that there's a court procedure. They all dress up like prosecutors, they dress up like judges, but there is no legal character behind these courts. There's no international agreement. There's no authority behind it, because there's no state who delegated power to it. It does not have, therefore, international character, and it does not respect the rule of law in a sense that obviously it's not an ordinary criminal procedure, and it's not even possible that the indicted person would be present in the procedure. And there's virtually no state support behind this concept. So again, this is rather an academic attempt, but not a legal solution. So within the last 12 minutes, then what do I think is the best solution, or what could be the most plausible solution? Well, again, there is the possibility to amend the Rome Statute in a way that it allows for the crime of aggression to be a crime where either territorial or personal jurisdiction would suffice to the court to proceed. There are questions and issues still with this proposal, for instance, the question of retroactivity, but the crime of aggression is still a continuing crime, and it is still committed today. So there are arguments for this solution as well. From the perspective of law, it is absolutely a plausible solution. If you have the support of the state parties, then it can be done, and it can be done in a legal way. It would be an institutional solution in a sense that it would result a permanent solution. So it would not only solve the problem of this case, it would solve the problem for the future as well. Because if you think about it, that would be the best solution. In the future, if you apply the either territorial or personal jurisdiction regime to the crime progression, it would mean that in the future, if the act of progression is committed by a state and accordingly by the nationals of that state, even if the victim state is not a party to the Rome Statute, and the offender or the perpetrator is not a national of a state party either, it would suffice for the victim state to accept the jurisdiction of the court, and then it would have jurisdiction for the crime of aggression. But this is why I don't think it is a plausible solution. This is a solution which would be so good that many states would simply not allow this to happen. I'm thinking of the United States, China, Russia, Iran, India, Pakistan. None of them are state parties to the Rome Statute, but having enough influence on their own to disencourage the state parties to actually carry out such an amendment. So this is why my solution actually would be to create an ad hoc international tribunal. You might think that I already refused such a solution, but what I refused is an international erga omnes court, which would mean a court established by the Security Council. But it is possible to establish a criminal court on an inter partes basis, meaning to establish a criminal court with willing states. And a very good example is the ICC. The ICC is an inter partes court. It was established by willing states, and it is those states who are obliged to cooperate with the court. And let's be realistic. States will cooperate with an international court if they want to. You can see it with the ICC as well. If the state parties do not want to cooperate with the court, they will just refuse it. So it's actually, even if it is not legally correct, but in reality, it's only the willing states who actually cooperate with the court. And it is also possible to establish such a court on a regional basis. So it is the EU which is most active in this domain. So if the EU decides to create an ad hoc court, that is theoretically plausible. If the Council of Europe decides to do so, theoretically it is plausible. And of course, the best solution would be to create such an inter partes ad hoc court with the support of the United Nations General Assembly. It would be, of course, a special court, so it means that there could be arguments stating that it's selective justice. But still, this could mean that there is more support from critical actors from the international domain, including the US, to establish such a court. So it is legally possible to create such a court. It is more plausible than amending the Rome Statute or creating an erga omnes ad hoc court. And although it's not an institutional solution in a sense that it is only created for this specific situation, if it succeeds, then it would mean that it crystallizes the understanding of the use of force, and more specifically, its international criminal aspects. And hopefully, in the future, it could provide munition for member states of the ICC to amend the Rome Statute, having clear, well-established norms in international criminal law. I do admit that there are still many questions. It is not a perfect solution, but I think what we should do in this case is to admit that there is no perfect solution, and it is better to have a solution which seems plausible and which poses the least problems when it comes to the international rule of law and legality. So I can leave this last slide on the screen. because that concludes actually my presentation. If you are having further questions, which you most possibly have, then I would be very happy to answer those. And I actually managed to finish within 24 minutes.
First of all, thank you both for the paper and for the presentation. Two things that I deeply loved in the paper and in the presentation. One is that you are extremely organized and clear, and it's a wonderful roadmap to see the different options of what is possible, what is less possible, and it's clear that which direction you want to take it, and I think in that extent the paper, I think that the paper is clear and organized, not than papers that I wrote in the beginning of my career, than papers that I'm writing today. So I was really impressed with that, and also I was very impressed with the motivation. There's a clear motivation to improve both the state regarding the enforcement of aggression and the state, and vicariously the state of international criminal law. So in those two regards, and these are the most important regards, so anything that I'm going to say later, any criticism, please remember these two regards. These are the most important regards, and I think that the paper is very good. What I want to do is there's some obligations, like if Manu is the grandmother of this workshop, so I'm the grand cousin or something like that. I've been in every workshop, and I have some obligation to bring some historical anecdote whenever I comment on an issue. So part of the historical anecdote is in the PowerPoint, but since the PowerPoint is not coming, I'll go to the more important issue which I wanted to address after the PowerPoint. And I think that my two biggest problems with the paper were the following. First of all, you go, as I said, you go in a very organized way through the different options and explain why formally these options are not possible. So if I go one by the other, you say the ICC is impossible because they created these two-tier requirement of jurisdiction. It needs to be both personal and territorial, and consent in both elements. You see, that's the Kaiser in exile. Yeah. That's Mohammed VI. That's the Sultan of Turkey.
Oh, the stamp.
Yeah. But we'll go. I'll start from this quote. Okay. It is not a coincidence that the contemporary international legal order was erected on the cornerstone of the prohibition of aggression by rendering the use of force illegal and punishing those responsible for the crimes of peace. International law intended to prevent war, the crime and genocide of most heinous atrocities. And I assume that when you wrote this, you thought Nuremberg and the UN, right? This is why I put Nuremberg and the UN in the back. And the story that we are used to tell ourselves regarding the World War I and the interwar period is that in the customary international law allowed to go into war whenever, and there were few treaties. The most famous one was the Kellogg-Briand Treaty, and only few countries were subject to this treaty. Now, this is the world that was subject to the Kellogg-Briand plus the Salvador-Lamas Pact. You see, the entire world, with the exception of Mongolia, Nepal, Yemen, and San Marino. And by the way, the accepted interpretation of the Salvador-Lamas Pact and the Kellogg-Briand was that it was referring to wars of aggression. So we had, actually the world that you imagine when writing the paper as being born in World War II, because this is the accepted legend we are telling ourselves, actually existed even then. Moreover, and when returning to the first slide, there were sanctions. It's true that in the end, a tribunal was not created, but all of them were deposed, with the exception of young Putin. If you don't recognize the second picture, is young Putin. Oh. But this is the Kaiser in exile, actually summarily punished to house arrest. He was not allowed to exit one county of the Netherlands. It was not even limited to the Netherlands, but only to one county in the Netherlands. All the rest were deposed, finishing dynasties of hundreds, if not 1,000 years. That's serious sanction. All of them got kicked out of their countries, had to give up most of their property, lost their citizens. So serious sanction, and it didn't create the same deterrence expected. So I'm going to tell now a different story about World War II. The big difference between World War I and World War II is that after World War I, they said equality of nations. After World War II, they said all animals are equal, but some animals are more equal than others. If to quote the Animal Farm that you quoted in the end of your paper for a different thing, and the thought was that you need to indulge the superpowers and give them a bit more if you want the system to be realistically stable. And I think that if we go back to today and go through the different options that you crossed off, saying we cannot go this venue because formally it's impossible, if you look at the rationale behind the formal law that made it is impossible, it's the same idea. And it's not, and I told you that yesterday. The worst thing in your paper is that you made me feel old. In the sense, and that's my fault, I'm getting old. In the sense that at a certain point, this realistic, you were critical about realism, a bit realism, these realistic, non-ideal solutions become more attracting. And there's good things to say about taking the right pace. And I'm connecting here to what the ambassador said yesterday. He's not saying, okay, now Trump has taken power, we are stopping all initiatives. We are advancing the initiatives with the partners that support those initiatives. And that is what the initiative to advance the criminalization of a crime of aggression is actually doing. Because when in 1996, when Trinidad and Tobago came and suggested creating the ICC, nobody believed that the ICC will be created. But enough countries came. And nobody believed that they will agree to aggression then. So they did Article 5 saying, once the countries will agree on aggression, we'll put it inside, we'll have jurisdiction on it. And I can send you scores of academic papers saying that's going to be a dead letter. And they succeeded to open the court by 2002 with the consent of more than 64 countries. 60. But there were more than 60. There were more than 60, 64 at the event of the opening already. Yeah. And said, okay, we'll agree until 2010 on a resolution on aggression, and nobody, and again, I can send you scores of academic paper from the first decade of the 2000 saying that's not going to happen, and you had Kampala. And Kampala, they agreed, we'll need 30 or 30 something countries to agree within 7 years, and then a 2/3 vote, and I can send you from the second decade of the 2000s, scores of academic paper saying this is going to fail. And they succeeded by 2017 to kick off the initiative for aggression, and currently you already have 46 countries on board. 46 countries, meaning a quarter of the world. And the worst thing that we can do is to move too fast. If you bake the cake in too hot of a temperature, it would simply burn. But the direction is the right direction. If you think, for example, if you go to IHL, Additional Protocol 1, it was signed in the midst of the Cold War because the Americans were feeling bad regarding Vietnam. And when Reagan came to power, I can again bring you scores of academic papers from the beginning of the 80s saying that is a dead project. Today, nearly 80% of the countries of the world are signatory to it. So there is a room for not pushing the envelope too much. And Russia is a problematic target because if you won't get it, it's fine to say, okay, you don't need to try to buy the superpowers. But that doesn't mean Russia is a weakening superpower. So even if you get it, people will say, that's not really the bite size, the real apples on the tree. This is not China or the US. So you won't gain a lot from getting Russia, but you are potentially going to lose a lot if there would be a backlash. And if I look around, international law is a state of a real concern of getting a backlash, if Trumpism and populism and so on. So at this stage, to do something that is a bit overboard has its dangers. I'll give one additional historical example and then say why you need to listen to me only 80% of what I've said, and then I'll conclude. So, historical example. We are here in Austria, the center of the Holy Roman Empire. The Holy Roman Empire was the equivalent of some kind of a European Union. You had 300 different sovereigns. And the Holy Roman Empire had two courts that had the authority to criminally try sovereigns and depose them for tyranny, which is the equivalent of crimes against humanity, and crimes against the peace, which is the equivalent of aggression. And they were, even though they are remembered for being inefficient and taking some cases 8 years and so on, generally speaking, each of them had tens of thousands of cases regarding various issues. But regarding sovereigns, they jointly deposed during the scope of 300 years that they existed, 50 rulers. That's a ruler every 4 years, which is amazing. Most of them for tyranny and crimes against the peace, with the exception of one deposed for idiocy. I wish we had an international court that was able to depose rulers for idiocy. But at a certain point, they became arrogant and tried to bite against Russia. And suddenly, suddenly, the Prussian prevented the appointment of judges, prevented budget to the court, and the court became dysfunctional. So we have the warning of history against going too fast or trying to bite too big of an apple. Now, what I'm saying I've pushed too much to the other side of your argument. All I'm saying now, if you take it back to the paper, is that what you said in the end, that you are aware of the faults, needs to be pushed back put into the core of the paper, saying, I acknowledge these weaknesses, but still this solution is best. At the same time, you need to take a bit more seriously the other options that you are saying that are not working, and not only deal with the formal reason why they're not working, but going back to the rationale of that formal reason and saying, yes, there is this rationale, but still don't listen to what I've said, because I know that you think that it should be pushed and it should be prosecuted, but you need to explain further and more convincingly, policy-wise and morality-wise, why despite these rationales and despite these difficulties, still your solution is the right solution. And I'll stop here. And thank you.
It's hard to decide whether you are agreeing with me or you are actually providing the counter-argument, because at one point I felt that you are doing a better job than me to advocate solutions which are really progressive. When you said that no one imagined the ICC would actually set up, suppression as a crime would be implemented. And in other cases, you provided the counter arguments, but it's all really thought-provoking. What I would like to respond to is actually the historical aspect, because you provided a really great in-depth knowledge I do not have concerning the responsibility of certain historical figures. But what I think is different to the historical solutions is that those solutions were political solutions. So the fact that the leaders of Austria-Hungary were expelled practically from their countries, that they actually were punished in a sense, but their responsibility were never really addressed as such. And the other problem with this kind of political approach is that it is always based on the victor's victory. So it's always the losers who have to meet the consequences. The modern idea of international criminal law is that you do not have to lose a war to meet responsibility. So in an ideal world, again, it's in an ideal world, in theory, if Russia does not lose the war and Russian leaders would not be expelled, they should still be prosecuted for the crime of aggression. So this is the main difference between a political solution, which is always an ad hoc decision-making, which is not based on any predetermined rules, to the legal solution, which exists on rules we as a community already agreed upon, and we decided to enforce those rules. And this is why I'm a big advocate of international criminal law, despite the fact that I see the reality of contemporary international relations, especially the projected future of international law, which is really gray, and the kind of taste for the possibilities concerning disarmament as well. So yeah, I think that was practically the main point. So I think a legal solution is always a better option because it is something which creates an equal understanding of rules instead of ad hoc decision making, which is based on power. But I really do appreciate all your comments. I do have doubts, and I do have thoughts about moving it to a better, more convincing format. So thank you very much. I do appreciate it.
Thank you for wonderful presentation, and half of the question you already answered with this response. That I was thinking of asking you about that. Don't you think that victors determine the consequences of war? So you already answered that. Another thing connected to the same thing, it's not a question, it's a composition. ICC's functioning created a doubt in the like-minded people that its functioning is biased, because most of the convictions took place against the African countries, those which are not powerful. And similar kind of, or we have not recognized them as similar kind of conduct, like attack on Iraq, attack on Libya, even if these countries are not ruled by democratic system, still there was no sanction from UN to attack. So the leaders of these countries who were attacking these Arabic countries or African countries, weren't they deserve to be prosecuted in ICC? Because look at the consequences took place after that attack. How many number of people died? How much life miserable has become in these countries? If we look from that perspective, can we cover it under genocide or war crime or whatever way their responsibility can be ensured? If the countries which are calling themselves as developed countries are not taking responsibility of their conduct, how can they ensure or how can they make the least developed countries responsible for the things happening in India and Bangladesh?
Well, the ICC always gets this serious accusation of being biased, and especially concerning African states. But let's be really clear about this. It's not the ICC which has this bias. It's the states. It's simply the fact that those states who should be prosecuted cannot be because they are not state parties. If you think about Iraq, for instance, the US could not be prosecuted by the ICC because the ICC would not have jurisdiction over such crimes. But if someone is more knowledgeable with this, please correct me. But if I remember correctly, there were ICC investigations against UK soldiers serving in Iraq. The only reason the ICC did not have to actually carry on with this procedure was because the UK actually carried out the prosecution and had to provide evidence to the ICC that the perpetrators are actually prosecuted. Again, it's just from my memory, so if I'm mistaken, please tell me. The point is, if the ICC has the tools and the support of states, then it can prosecute the most powerful ones as well. But blaming the ICC for the non-willingness of states and for politics, I think it's not really an adequate interpretation of the legal reality. And for the case of UK, to prove again the ICC's merits, without the ICC and without the UK being party to the Rome Statute, most possibly there would not have been any prosecution against the UK soldiers committing crimes in Iraq, because the UK carried out prosecution just to avoid the ICC to do the same, because obviously it would be a huge lost reputation if the ICC carries out justice against UK soldiers who committed crimes against humanity or war crimes. I'm not really sure about that. Main point is, I think we should rather strengthen the ICC instead of bombarding it with unbased criticism. There are a lot of criticism which are well-based. I think being biased in situations is not really a well-based argument.
Yes, thank you. So this was a wonderful presentation, very clear and structured, so it was great to follow. I have a few points that I would just like to flag, with the understanding that I haven't read the paper, so I'm following the presentation. So just from the presentation, we're concentrating on the head of state, Minister of Foreign Affairs, Minister of Defense. And just to be clear that the leadership clause is, of course, broader. It does not only cover those three persons, but it covers many more. Yeah? I think there's one comment, and that has to do with the question of whether the situation in Ukraine, or the aggression against Ukraine, could be prosecuted before the ICC. And I think it's the same answer for an Article 12.3 declaration for a Security Council referral, as well as an amendment. So the problem that we have is when the compromise was being forged in Kampala, and we were there drafting a lot. So we opted for the subjective entry into force of the amendment. That means we don't have one objective date when the Rome Statute was changed to include a definition of the crime of aggression. So it's very difficult to go back in time, although it would be in principle possible to define a date when the statute was objectively changed, because it doesn't exist. So the only date that you could go back to is maybe 2017, when the jurisdiction was activated. So that would be one argument. And then, well, we can't cover all acts in relation to Ukraine, because of course we want to start in 2014 and not in 2022. Then you could argue with the continuing crime. Yes, but it's still a difficult argument. And then of course the other question is whether 12.3 is at all can be applied at all to the crime of aggression. There's a problem with a hybrid court being part of the Ukrainian judicial system, because it's problematic under the Ukrainian constitution. Yeah, I'm sure you
I'm
know.
not familiar with Ukrainian domestic law, so I would believe everything you say.
Okay, so then believe me. No, so that there's a provision that judges must be Ukrainian, and there can be no international judges in the system, and there can also be no special tribunals. So that's why at the time when they were discussing the ratification of the Rome Statute the first time, there was a constitutional court decision in kind of a way out via the international solution. So if you have an international or internationalized court that is separate, it's probably easier to argue than one having within the system. And then maybe to not take too much time, one aspect that I would like to mention with regard to amendments. So you presented the amendment process or the discussion about amendment very much in the context of Ukraine, and I think it's completely out of the context of Ukraine. So of course we had this one proposal by Luis Manuel Ocampo, but I think it's extremely unrealistic. It would take a lot of time, and then you still have the question of a retroactive application of the law. So the discussion that we have at the moment, and states have started this, there's a group of friends that is discussing amendments to the Rome Statute, is really a separate process that would change the jurisdictional regime of the crime of aggression and harmonize it with the normal jurisdictional regime for the future. And at the same time discussing a possible solution for the conflict in Ukraine, for the aggression against Ukraine. And then the amendment process could also be used as an argument against the selectivity or selective application of the law, because you create a special tribunal for one situation, which is an unequal application of the law, but at the same time you commit to change the jurisdictional framework for the future that would then be enforced for all states parties. Yeah? So the discussions are linked, but I don't think there's a serious discussion still ongoing with regard to changing, amending the Rome Statute for the situation in Ukraine.
Thank you very much. These are very substantial points, and I really do appreciate them. I think the only thing I might want to flag is, which is completely not contrary to what you said, is that I do share that amending the Rome Statute would be a really long and painful process, and it should rather be done for the future. But this is why I think that my conclusion was to actually go with an ad hoc court, despite the fact that saying that selective justice was part of the process. Because I think if we just accept that we should amend the Rome Statute, even if it takes a lot of time, and I don't think, I'm agreeing with you, I don't think that there's actually a substantial support within the member states to do that now. You don't see that? Do you think there is substantial support? I mean,
no,
I will
didn't
accept
say that,
yeah.
but I wasn't negative. So I think there's still, there's still a political momentum where states could join and move things forward.
All right. Okay. That's, I would rephrase it. Even if state parties decide to amend the Rome Statute, it does not automatically mean, of course, that it would result in the prosecution of the crime of aggression, maybe because of the problem of retroactivity, or simply just there's no realistic way to actually enforce those norms. And the reason why I think an ad hoc court would be a solution is because following the news, and it's of course not a kind of substantial academic argument, but following the news, it seems to me that supporting states do prefer the ad hoc solution because it's less restricting and constraining for them for the future, first. And second, it is better to prosecute the crime of aggression, even if it has this kind of one problem of selective justice, because in domestic criminal law, for instance, criminology studies suggest that it is consistent enforcement of law which actually creates prevention, not the amount of sentence not the severity of the sentence, it is the consistency. So if the perpetrator knows that he will be prosecuted, then it will prevent other perpetrators. So this is why I think it's better to go with an ad hoc solution, even if it is not really according to my taste. It's not really according to many scholars' taste, because they think that they're just sick of all these ad hoc courts, and we have also really bad examples which not really develop justice. And hopefully this could result to the amendment of the Rome Statute for the future.
Okay, thanks for the presentation, for the paper. I enjoyed it very much, this intellectual road there. I have 2 points, maybe one preceding. I'm wondering how old your respondent is in terms of his... Just kidding. But the substantive comments are, first you mentioned about the role of international criminal justice to address this particular situation. But we know that this situation is not special one. From the history we also have this Western states that enjoyed manipulating with the prohibition of the use of force in Afghanistan or in the Persian Gulf. But on the other hand, I see the prohibition of aggression in dual manner. So firstly, from the state-centric perspective, and from the perspective of the international security, peace and security. And my question to you, just a simulation, let's call it, of in your opinion, is it a failure, the impossibility to prosecute the leaders of the Russian Federation for actions, let's call it from 2017? Is it the failure of the international criminal justice or international peace and security regime? This is the first question. And the second question would be, please don't consider it rude. I like to ask this question also when I'm writing my own de lege ferenda solutions. So what? So imagine that all these obstacles to international criminal law being able to prosecute the leaders in this particular situation, what are the other consequences, so-called side effects of that? We can see the statements of states, the reactions of states after the OTP of the ICC requested arrest warrants against the Israeli leaders, and the threats or concerns among The Hague concerning the freezing of assets of the ICC because of the US not being really a willing state to support such an initiative by the OTP. How about the consequences for, let's call it, European Union takes the lead in that? What would be the side effects for the European Union member states if we manage to convince all of the European Union member states to establish such a proposal that you have? And eventually, do we need weak Russia in the contemporary world?
What was the last question?
Is weakening Russia as a state based on that solution, that if effective, what happens next? So let's call our imagination and ask ourselves if we need this to act only ad hoc, and to, instead of thinking more in a structural manner about the solutions for the future and not necessarily for the ad hoc ones.
There's a lot to cover.
Don't cover the issue of my age.
I won't. You have my promise. First of all, I'm not Nostradamus, although I could be actually, because he was wrong in practically all of his predictions. So I think the two main questions, the first main question I wrote it down was, is it a failure of international peace and security or international criminal law? first you could say that it's the failure of both, but I would rather say it's not a failure. It's a challenge or a momentum for the international legal order in general to address the issues of contemporary international legal order, which is based on the prohibition of aggression. Because the whole idea, basically, of the international legal order after the Second World War, or actually going back, if we follow this idea, but at least what happened after the Second World War is to give very exact legal binding sources of law and mechanisms which work as they work with a lot of imperfection, but you have the source of law, you have the mechanisms. So that was the idea. The idea was that if you have disputes with another state, then the way to go is international litigation before the ICJ. If anything happens, then you have the international criminal justice system, and you also have the United Nations as the political actor of the international legal order. So in a sense, it is a failure, but in another sense, it is an opportunity, now seeing the weaknesses, to actually do our role and find solutions which work. So why I said I'm not Nostradamus, and I'm also not an expert on international relations or international politics, is I cannot tell you what happens if we weaken Russia. It's not my job. It's not your job. We are lawyers. So what we need to do is find the most adequate legal solution for a problem, applying already existing international norms, because that is how we strengthen the international rule of law, which already exists. So the main objective is to enforce what already is there, so that in the future you have a better system which works. And for what's the side effect? I think the side effect of creating an ad hoc court would be a good momentum when you can actually reach a conviction for the crime of aggression. Any other thing than that, apart from the development of international law, I just simply do not know, and it's not really my job to address. So I just admit my lack of knowledge on that.
Short comments before we move to that. One, just lawyers, you're also academics. We have
that is
more
true.
vision than just lawyers.
But I would like to say, as academics, we know the limits of our methodology, and that is what the point he made.
But we don't have a limit to our vision.
Outside of our methodology, yes, we have visions.
And the second one, no matter how old is the respondent,
No,
still younger than me.
But only in 1 year. Only a year older.
A year is a lot. Not yet.
Yeah, I don't really know whether I want to pose a question or just speak my mind. This maybe much more a question. So yes, you're not a Nostradamus, neither are we. But between ICC and the ad hoc tribunal, would it not be better to prefer ad hoc tribunals and really strengthen the idea of establishing ad hoc tribunals under the orbit of General Assembly, rather waiting for, the glorious day of the ICC statute,
But
change.
that was my argument.
Yeah, but yes, that's your argument, I understand, but I'm just posing a question out loud, either in support of your argument or not. Well, much more for support your argument, but in my understanding and from what I've seen, because I also had to deal with the ad hoc tribunals under the realm of Ukraine and other armed conflict contexts, I think it's yes, selective justice is there. One could argue like that, but it's the most viable tool, I guess, for the future. And maybe now as a question, much more, involving Ukraine in this or not, how do you think it's better for this mechanism to really be, launched, evading the dicta on selective justice?
Well, thank you for agreeing with me, because I think we practically have the same conclusion. So I will just add shortly to this. I think an interesting example would be for selective justice and why is it important to have. So you provided me an opportunity to actually expand my argument. It's the Nuremberg and the Tokyo trials. I mean, there were a lot of problems with the idea that those who won the Second World War punished those who lost, without ever addressing the responsibility for dropping the atomic bomb, for instance. At the same time, the Nuremberg and the Tokyo trials did address criminal responsibility in cases when evidently international crimes were committed, and very serious international crimes were committed. And even though it was selective justice, my argument is that selective justice is better than no justice. And ultimately, even though you can criticize that the US officials or high-ranking soldiers were never actually prosecuted for international crimes committed during the Second World War, but due to Nuremberg and Tokyo trials, the international criminal law as a concept occurred. Without this selective justice, it would not have happened, most probably. And yeah, I think that concludes. Maybe just one addition that although it was selective justice, it was important to record actually the incidents and to do so in a way which cannot be criticized afterwards. So what happened, and we describe it as a Holocaust, for instance, it is very hard to deny the facts now that we have Nuremberg trials with the documents, with the records, with the defendants expressing their views and with the prosecution expressing their views, and then the judges deciding on those facts and law. So again, selective justice is not the best, but still better than no justice.
For my understanding, I'm sorry if you already said it, but I don't quite understand it. On which basis, legal basis, would this international ad hoc tribunal be established? Would it be a contract, or because Chapter 7 wouldn't work as the Security Council would have been paralyzed through Russia? I didn't quite understand it, on which base it would be established.
If I understand correctly, then it would be an international agreement.
Okay.
In the willing states.
Who would be party to that agreement?
Again, willing states. But those, I cannot give you a list.
Have to get Putin, for that matter, in their hands, right?
So do you mean that it will be?
You want a trial against the aggression of Putin against Ukraine?
Yes.
Unless you want to do the trial in absentia, you actually have to have control over Putin to bring it.
Or somehow, yes. That's something you cannot solve. So that's the reality you cannot really overcome. I do agree. So in absentia, I don't think it would be a good idea.
A response or a follow-up?
Yeah. Well, I see Wim Zimmermann as well, but I would like to also respond. It's a reaction to what you said.
Well, just a bit about the setup. Like, if you establish a court by agreement between a bunch of states, let's say the EU supports it in the Ukraine. In general, I'm very sympathetic to the idea, but how do you deal with that the immunity of the head of state is taken away as a sort of pacta tertius kind of problem, where in most situations, if the Security Council intervenes, sure, that's great, that solves the problem, but I think you also see it a bit with backlash in the al-Bashir kind of judgment that, yeah, this problem of creating or undermining the rights of different states if you create something to which Russia would not be a party. and not only for apprehending Putin, which would be the crime, but also just from a legal perspective, the immunity itself.
Yeah, maybe or to follow up on that, because my points relate to this. Two separate issues. Well, one that I'm glad that you advocated for not bombing the ICC. Always good. Astrid already mentioned the question of the aggression kind of before 24 February 2022, and you do not mention that in your paper. You kind of take February 2022 as a point of departure, but I do think it's very important to actually at least acknowledge that the events before the occupation of the Crimea, etc., that could obviously also be seen as aggression, and then either just take a position why you're not dealing with that, for example, for temporal reasons, but at least address it in your paper. As another comment, more general comment, you in talking about Nuremberg, and also now it already mentioned a few times, is the issue of like victor's justice. It would be nice if at some point Ukraine manages to win, but at the moment it would actually be loser's justice. And then that relates to the issue, like, can a group of states, the loser potentially, then, like the victor's justice, at least if you want to call it like that, but Nuremberg was based on the law of occupation. They were there, they were occupying the territory there, and they could, under various, on a legal basis, could actually carry out trials also there. And should you want to allow in international law that a group of states, and that's a question that I have, how big should a group of states be? This coalition of kind of the willing in order to make this a viable tribunal then, be able to kind of try to impose its will on a non-member state of essentially what is a treaty based tribunal then. And it was already now raised by Ido, so he added a T too much. But what you do not address here, and what is one of the key reasons why people put forward a hybrid with Ukraine, is because that would allow for trials in absentia. The ICC, irrespective of the crime of aggression not being possible before the ICC, but also you would follow a more standard, other than the Special Tribunal for Lebanon, but more standard international tribunal approach would be barred from conducting trials without the suspect present. And I think it would be good to at least engage with that, and how that would relate also to your view on the legality of such a tribunal, because the reasons is because you say you want it to take place, it's better to have selective justice. You only can get to justice if you actually have a trial that is carried out, which would then appear to imply that you accept that it would be done without the suspects present. And then I just have one additional question, whether you purposely or were aware of the difference between your title, which was specifically focused on the human dimension, but then you seem to make the transition to animals at the very
end. Very interesting argument, the last one already. It's just an observation. I have not really think about it, so I would be really happy to take it as an opportunity to say that yes, it was a very clever linguistic way to express something. Unfortunately, I'm not that clever in that sense. So it's a coincidence that human aspects animals, although now I see kind of a relation. I think I can address practically two questions. But first of all, aggression before 2022. Obviously, it should be addressed, and I think it's also already addressed in the ICJ case. I don't think it is necessarily a need to address it in a criminal court as well. Would be nice kind of argument, but it's not. I don't think it's necessary, especially if there's a record on the aggression, on the act of aggression before the ICJ, for instance. The loser's justice, can it work, and how many states should it entail? Well, obviously, I don't think that there's an exact number, but I understand that if there's 30 winning states, that's highly questionable whether it could work, and I don't think it would really have an impact unless, for instance, there is a regional solution. So I think if it's a regional ad hoc court, for instance, I can see arguments for a court established by winning states within the Council of Europe, for instance, and maybe 30 states would be sufficient. But obviously, if you go for a more international or a global approach, then a number should be similar to the state parties to the ICC, which is a really challenging demand, and maybe at this point is not too realistic. I admit that. And now I turn to the pacta tertis arguments or counter-arguments. Well, obviously it would be a pacta tertis rule, because it would mean that states create an international court and decide that this court would have jurisdiction on the basis of either territorial or personal jurisdiction, in this case territorial jurisdiction. This is a clear pacta tertis rule. But this clear pacta tertis rule already exists within the ICC statutes. And although states who are not party thereto always make criticisms about it, but it's already part of the international legal system. And I'm really not an expert on international cooperation when it comes to extradition, but correct me if I'm wrong. If I understand properly, if there's no extradition agreement between two states, you can actually prosecute a national of another state. Of course, immunity of state, head of state officials would apply, but a good argument why head of state's immunity would not apply, even if there is a pacta tertis rule in general international law, is the Nuremberg Principles as acknowledged by the General Assembly after the Nuremberg trials. Because Nuremberg Principles states that the official capacity does not exclude criminal responsibility. I think this could have been the munition for the ICC as well, for the either territorial or personal jurisdiction, which allowed to the ICC to prosecute potentially perpetrators of non-state parties, and reading this together with Article 25, even if those perpetrators were high state officials. So it is not the most convincing argument, but to conclude, my argument is that the ICC already operates on a pacta tertis rule based on Article 12 and Article 27. It theoretically allows the ICC to prosecute perpetrators who are high state officials of non-state parties. And I think there was only one question about hybrid courts and in absentia. I'm not a fan of in absentia. I would not be a huge supporter, but luckily for me, it will not depend on me. But I think that the principles of criminal law should be maintained at the highest level possible. So personally, I would not argue for a hybrid solution with an in absentia solution, because it would definitely mean derogation from already existing and core principles of criminal law. The defendant has the right to be present, has the right to defend himself. That is true. There are counter-arguments, so I would not be mad if this would be the solution, because ultimately it could result at the end of impunity. I'm not a huge fan of it, but it's not an academic argument, whether I like it or not. I think it would be a derogation from principles of criminal law.
Last question.
Yeah, well, probably us and I will dispute now anyway. So, you
Right.
see, it's not really a question, just a remark. So, I would argue that the ICC statute honors the immunity of head of state of non-state parties and others because of Article 98, even though you can argue that the court itself modified a little bit the rule. So I wouldn't take the ICC statute as a good example to say that the Pacta Tertiis rule does not apply anymore. But that was only a side remark. Us and I always quarrel about immunity, and she has a different take to that. I had, just as an idea, you might want to discuss that, I thought about the Sierra Leone special court of Sierra Leone. I thought it was one of the worst judgment I ever read. But, to a certain degree, there is as inspiration, a vision in it, to come up with a vision that is to, under Guterres, hardly possible, but anyway, an international treaty between Ukraine and the Secretary General, which internationalizes the court according to the special court, which then on the basis of that said, Charles Taylor doesn't enjoy immunity because, pointing at the International Court of Justice, there is no immunity before an international court, which on many levels is painful for me, that kind of argument. However, if we build on that, we can say there is a flaw in reasoning in the first judgment, but maybe the second judgment, which builds on that, then creates customary international law. I only want to put that out. Don't look at me like that.
Smiling.
It is a wonderful idea.
It is.
It is. Now, we do not have the right Secretary General right now at the UN, but that might be a short-term problem. And then certainly it loses justice. But you know what? Maybe it's time for that. Yeah. Maybe we should embrace the fact that not only the winners dictate justice, but also losers. And if the price of absentia is to be paid, if Mr. Putin wants to have enough lawyers, wants to make a point, just send a letter towards the court. Yeah, even though I agree human rights wise it's a bit problematic.
And just a very short question. So I will not dispute this because you laid the arguments so perfectly that if we have one president, we can build from that, and maybe that's a good argument, including Nuremberg. But I have a short question. So in terms of numbers, and then you said, maybe 30 is not enough when we are talking international, but maybe 30 is enough when we talk regional. So I also would not support the Pacta Tertiis, but if you do, so would that then be possible on a regional level? You would argue that it would be possible to have either a multinational regional treaty or a bilateral regional organization, Ukrainian treaty-based tribunal that would not need to respect immunities? Is this what you said? Thank you.
Just referring back first to the Pacta Tertiis rule and Article 98. Again, since this is from my memory and I need to look into this, if I'm mistaken, please tell me. But if I recall correctly, before the BRICS conference in South Africa, South Africa had the intention not to carry out the arrest warrant against President Putin. But the judicial system and the argument was based on Pacta Tertiis and immunity of head of state officials. No, it's Putin.
No, Putin as well.
Yeah, it's a BRIC conference. And if I remember correctly, they actually asked the ICC to clarify the meaning of Article 98 and whether South Africa would be obliged to arrest Mr. Putin and hand it to the ICC. And if I remember correctly, the ICC decided that Article 98, despite the Al-Bashir decision, does not relieve South Africa and does not mean that Mr. Putin would enjoy immunity. Problem is, the decision was not public.
Yeah, better not.
it was not public, so we do not know the arguments of the court. What we know is the outcome of the liaison between South African judicial system and the ICC. So again, since it's my memory, I can make mistakes. So correct me if I'm wrong, but this is how I remember to it. Now back to the question of numbers. You caught me in a really shaky ground because again, I'm not an expert on what is plausible in international relations, which do have its roots in international law, but the question of numbers is rather a kind of question of reality and facts. But I think that a multilateral solution would be the way to go. And the reason why I said that it should be the Council of Europe is because it has kind of geographical aspect, which entailed last Russia as well. So I think it would have more legitimacy to establish an ad hoc court, more legitimacy than the EU, for instance. But whether immunity, I think immunity would not be a problem simply because of the fact that regional agreements are also international agreements. The European Union is still an international organization. It's kind of evolved from the Council of Europe is still an international organization. So a regional solution is still an international solution. So a regional agreement which establishes a regional ad hoc court is, under my understanding, is still an international hybrid. It's still an international ad hoc court. Therefore, based on the Nuremberg principles, immunity of head of states would not be a problem. And there's also an ICJ case, I think, regarding the Congo arrest warrants, which stated that before international criminal courts, immunity of head of states does not apply. So that would be my answer for this specific question.
Thank you very much, Zénó.
Thank you.